Hey everyone, welcome back to Blogs in a Maze. It's been busy couple of weeks. A couple of weeks ago I went through a contravention hearing, which I want to talk about today. Just a short disclaimer, I'm not a lawyer, not a therapist. Opinions are my own. All I focus is purely discussing the process, what I went through, what you could expect. And if you need help with anything, please contact a lawyer. If you need assistance and you're located in Australia, contact Dads in Distress. I will leave a contact number in the information below. To my contravention order, so I started contravention order in 24 after I've been refused to see my son in September 24. Prior to that, we made a final orders agreement by consent, and everything went well until one day my son refused to go with me and spend the weekend with me. It was very sudden and very, very stressful situation. You don't want to force your child to be with you, but you also want to be with them. But I let it go then. On that day, it was just sad and not much happened. But slowly it progressed into just constant refusal of visitation. The mother blamed the son. She claimed that he does not want to see me, even though prior visits were very good. We had activities together and we had lots of to talk about. But this attitude changed suddenly, and the mother blamed the child, that time 7 years old, that he does not want to see me anymore. So I got my lawyer to contact the mother and issue a notice of breach of orders. In Australian law, the orders to be followed unless there are um, good reasons to breach the orders, like for example medical treatment or maybe a holiday or something serious. That's, you have to have a reasonable excuse to breach them, and the wishes of the child are not one of those reasonable excuses unless there is no harm or other things related more serious to it, which there were not. Anyway, so yes, some mother was issued with notice, didn't reply. Then I've decided to go through with the contravention orders, contravention application. That's in the case when the other parent, doesn't follow through with the orders. So there has to be a contravention hearing. I've approached my lawyer, also approached a number of other lawyers to get an idea of the price. I've been quoted about 20,000 Australian dollars for processing that application. Obviously, they give you no guarantees of the result or no guarantees of the final price. Which on that I've decided, after reading through the paperwork was available on federal court circuit. I've decided to do the contravention application myself and perhaps be self-represented in the future. I've started the contravention application about October, November. It took me 2 tries. Third try was accepted. So first try was refused based on the first and second try were refused on the basis of the technical structure of the document. Document should be, or there's a specific procedure how to fill up the document and how it should be all put together, which is probably one of the reasons why the cost of the contravention application is so high for the lawyer. But on the other hand, as professional lawyer, it shouldn't be that hard for them to fill application like that up. So yeah, it was hard for me because it was my first DIY application. So it took 2 tries. One was because of the dating in it. I was trying to when I got to writing the application, there was over 70 counts of breach, and majority of them were really same. So there was a breaches in the phone calls, which occurred pretty much on a weekly basis. The breach was in the length of the phone call, so from 1 hour, the phone call was just 1.5, 2 minutes. It's just there's no reasonable excuse. And for your information, that's still today, 2 years later. Sorry about ambulance. So there was majority of the breaches were in the phone calls, which were just pretty much same count, just with different dates and times. So I bunch it up together and I put in the contravention order like a date range, and similar I did for the other breaches where I was not allowed to see my son, so I put a date range in there. Then I stated separately no defamation when I'm being bad mouth and other counts like that. So just for your information, anyone who wants to fill up their contravention orders in Australia, other states, other countries might be different. Australia gonna have a nationwide same system. So the contravention order application has to follow specific technical form, which is stated on that application. So do follow that application. If you have a multiple counts, like myself, do not bunch them up. Each count has to have a specific date and location and stated what count was breached. So I got one refused, I returned it, and then I got to write a second one where I stated one by one all 70 plus by then counts of breach. That application was accepted, but in the first hearing in front of the registrar asked me to limit the application to 10 counts, otherwise it won't be accepted. Pretty ridiculous, in my opinion. I did agree to that, so to go ahead. Also, did not want to spend time on a legal representation. I did seek a free legal advice, and they agreed with that. registrar, so they just suggested me to just put the most serious um, counts, which I did. So I stated all the breaches where I was not able to see my son, um, and then I put just one breach of, excuse me, one breach of phone call the length, and I went with that. So the application was taken in consideration about March of last year. Um, right after that, the register ordered us to do another mediation. That was mediation number 3 for me in this long procedure. Mediation, yeah, pretty much. You've probably heard it before. Waste of time. The other party didn't want to really solve any problems. She was standing firmly by whatever she thought is correct. On that mediation, we did agree to start. Sorry about that. Another ambulance. On that mediation, we agreed to start a family therapy, which I was fairly happy to agree to, because by then my son was, or still is, emotionally damaged by his mother due to severe parental alienation and just purely, I don't want to say hate his father, but he just refused any conversation with me whatsoever. We still do have a phone call, video call twice a week, but he just, yeah, show up, and it takes 1.5 minutes. I don't get to know anything about him. He doesn't answer anything. So I see he's well, but there's no relationship really. Yeah, so we agreed to therapy, um, and we agreed for psychologist for my son, and my ex-partner is supposed to start visiting somebody, and me and my son obviously attend the family therapy, the reunification therapy. That was supposed to happen like in the orders. It was within 7 days, organize this and that. So yeah, we organized it. Unfortunately, that was about May 25, and by the end of the year, my son visited the reunification therapy twice. On both occasions, he was reluctant to talk to therapist because, first of all, she was a stranger. Second of all, who knows what the mother told him? If she told him to not interact with the therapist, he would not, because he just does whatever mom wants. So that was really unsuccessful in that matter. So yeah, 2 visits in a half year, where that's not gonna solve ever anything. His visits to psychologists, there was probably 10 plus visits. The, the psychologists, after I approached them, they refused to talk to me, even though I had permission from the court, which was in the orders. And the reason was that the time when I called to the psychologist, the original person was about to leave. Then it took a number of time, about a month, to find a new one, put him back on the list, and the new one didn't reply my email or anything. So yeah, I'm due to send another one, but yeah, trying to chase it down. It's just yeah, very hard. Everybody just trying to play stupid and yeah, incompetent. But through this contravention order, I got a hand on a number of subpoenas, which were very depressing, and you could just see the alienation pattern. What been said, what he said to the psychologist. It just, yeah, he's been told lies, and because the psychologists they don't want us, they're not looking for second part of the story. They just take in account whatever they've been said, and pretty much they just affirm affirm the child or the mother in whatever beliefs they have. Um, Consequently, there's not really it cannot really help anyone, if you just affirm their beliefs. So that didn't go anywhere, and in December of 25, on the last hearing, uh, after the registrar questioned me if I want to follow through because there was nothing happening with the contravention order, I've decided to follow through and get the hearing going. That was listed for March. So beginning of March, we're supposed to have a hearing. The register put in the orders that I'm available to get legal aid because there's such a thing in Australia. You cannot cross-examine the other party if there was accusations of proven domestic violence, which in our case there were accusations, even though I was found not guilty. That doesn't matter. So yeah, I could not cross-examine. If I'm self-represented, I could not cross-examine the other party, which is my ex-partner, and I got a leave to seek for a legal representative through legal aid. Uh, Supplied a form. They got back to me. They assigned a legal representative to me, and when I tried to contact the person here in Adelaide, I've tried phone call a number of times. I think 4 times. I've tried an email message, and the lawyer just did not get back to me. Very, very stressful period. Then I tried a number of different lawyers. They did get back to me, but then due to it was about months and something before the actual trial, they were reluctant of taking on a case. One of them had already something for that day. The another one said there's not enough time. So we went back and forth, and then there happened another curveball from the trial in front of register over the video link. It became an in-person trial in front of judge in person in Sydney. I live in Adelaide, about 2 hours flight. So, and also there's a different, not different jurisdiction for the court. The court is federal, but different jurisdiction for the legal aid. So I applied with Legal Aid South Australia, and the court was in New South Wales, which I think it would be solved in time. But by the time we got to that, I've decided to self-represent. So I started to reading up a lot on law, going through the paragraphs. Look, it's overwhelming at first, but on the end, it's feasible for regular person. I'm not really highly educated bloke. Work in a fabrication, but I can read and I can think. And once you start putting all the evidence together, you start putting a timeline. It all starts to make sense. And the basis for everything is be a factual. Do not try to throw in any other unrelated things. And that's how I started to build my affidavits and reply affidavit, and then case outline and things like that, and the actual speech for the court. So before the court, there's a couple of things that happens. So we were supposed the other party, the respondent, had an option to supply response affidavit. It's 2 weeks before the court hearing, and then I have option to supply my response to the response affidavit. In their response, there was some another allegations, that were not related to the contravention order. They brought up other things, and their their reply to my accusations was, "Oh, just because I felt," the mother said, "I felt like he wasn't safe, and I felt it would harm him." So they start playing this game of victim and harm. If they want to just excuse themselves from not following the law, which most likely would probably work. Um, and then I put up my reply affidavit. By then, I got hands on some other subpoenas, so I had more information to reply. There was lots of contradicting evidence they were trying to put in front of me. For example, there was accusations of my son trying to um, self-harm in a sense of biting his nails, not any other sort of self-harm. So he was biting his nail into, so he was starting to bleed, and on the toenails. The mother proposed that it was due to my interaction with him, which actually did not correlate with her visits to the doctor or prior year before that. Her lawyer sent me actually images of those fingers on my email, and I was able to um, get the metadata from the images, and the dates were completely out. There was no relationship. One of the images were way earlier from the years before when our relationship was still good, and the another images was months after I saw him last. So most likely, all those images relate to him being anxious around his mother, if anything. Anyway, so I'll reply with that, and then the last thing is a case outline. You have to. They will ask most likely to provide, and in case outline, uh, as it suggests, you have to outline briefly what happened in last relevant relevant timestamps in your past, um, brief outline of the case, and other precedents laws or judgments that it's based on. So in my case, it was contravention hearings, and a note providing reasonable excuse for not visiting, for not um, following through with the orders. And when the court gate came, yeah, it was a very hectic day. Obviously, couldn't sleep day before, and just keep and think about it. And just myself, going in front of the judge, dotting tasks. But I got there. I met with the barrister from the other side first. The barrister suggested if we want to make some sort of agreement. Well, I was like, well, we are not very far apart with the agreements, but there's lots of things that we would have to discuss. So we got in front of the judge. The barrister said that we would like some time to discuss things. The judge was happy with that because she stated she has some other things to attend, which I found really weird. If you allocate 1 day trial, 1 full day trial for not a client, for a case, and then she has booked in like some other, I don't know if it was like a, yeah, another hearings or something. So yeah, we started at 10. We got back in at 11:30. In between, we discussed some stuff. Oh, and prior to that, the first at 10 o'clock, the judge was questioning really why I am representing myself, and if I'm aware of everything, and why I don't have legal aid. If I was so I explain her my point of view, but yeah, the feeling was that she wasn't very happy that I'm there by myself representing, and she urged me to either come to agreement or to go and get legal aid representative, which is present in the courthouse. I did go to them, but yeah, I didn't get them to come with me into the hall, into the courtroom. Um, we did discuss it with the barrister. The possible orders. The orders they proposed were pretty much reset to orders from 2024, which was just ridiculous. They again wanted me to go through supervised visits, everything paid for by me, and limitation of the and slowly introducing the unsupervised visits. Yeah, it was just completely reset back to what it was. Not even acknowledging that their client breached everything. Yeah, ridiculous. Anyway, but then I pressed them. I said, yeah, we're not doing supervised visit anymore. The therapy mother has to pay for, and overall, we come to the agreement without judge getting involved. I do, I do regret making agreement. I should be tougher. I should press. I should follow through with the contravention orders and seek some sort of punishments or repercussions for her. My main concern, which I said to the barristers and later the judge as well, was, pardon me, I'm very concerned about the mother not following through the orders. She done it before. There's nothing that um, would prevent her from not following orders again. Well, what the barristers can say, they're representing their side. They say they understand my point, but it is what it is. Fair enough. The judge, on the other hand, said, well, if that's the case and she's not following the orders, we will see each other again here in front of the court, which is just absolutely ridiculous. Like why the court does not want to enforce in any way. There's already been number of breaches, and they are just reluctant to do anything with it. Okay, my fault absolutely is not pressing, not being firm, and being too agreeable. So in my case, it's not win at all. Partial loss. We restarted the orders. I should be seeing him next month. But the question is the mother going to follow through? I don't think so. Maybe once or twice, and then he's gonna go back to habits. I am preparing myself. There's a good chance that she gonna try to accuse me of something. So yeah, for those of you that are in the situation, there is lots of free legal advice. I just wanted to share what happened to me. It doesn't mean that happened to you. It's all unique cases. If you do want to self-represent, I've used a fair bit of Grok AI. I was using the 4.2 version. I didn't find the 4.1 version as efficient. I think now it's normally available, but the time when I was doing it was still beta. And I found out that the AI can really well reason and go through the actual law in a minute, and cross-reference. I uploaded my affidavit. I uploaded her affidavit. I uploaded a fair bit of documents, and then I got the AI to cross-reference accusations, dates. The AI spit out my strong parts, my strong positions, which I should focus on. And it really helped to get my head around, get a bit of confidence in the case, and then also structure the document in a good, reasonable language. I'm not native speaker, so English is especially law-related language. English is fairly complicated for me. It's easier to read, obviously, but to express myself, it's hard. And The AI really helped. I was using ChatGPT as well. It wasn't bad, but I was doing majority of the stuff through Grok because it can remember the whole conversation and just go back and forth. So I would probably recommend if you think of self-representing, definitely utilize that tool. Um, Always cross-reference, double check whatever the tool is giving you. It can be wrong. It can be wrong in referencing days, or it misrepresent some facts. So always double check. Otherwise, it can bite you in the ass. But it was really helpful. As I said in the introduction, you can contact agency, not agency, a group that's in distress, which I will leave information below. Very good group, probably one of the, I haven't found better one in Australia. Very supportive. They offer once a week there's a professional person on Zoom calls, so you can add, it's all free stuff. You can join them. There's multiple meetings online a week. If you're in a major city, there is definitely a group which we can find in person. You can attend in person, and it's all confidential. There's lots of those blokes have experience with what happening. They went through similar things. They can advise you what to do and what not to do. So yeah, utilize these things. Um, I know that this video is not probably what you expected. Maybe you expected some step by step how to do contravention. If that's the case, um, leave a comment below. There's lots of other resources on the YouTube. Unfortunately, the law is different from country to country. There's some parts of it is same, but this is what I've experienced in Australia, and I will keep you updated on the progress. And thank you for watching for now. And I'll try to make some new videos soon. There should be one coming next week. There's some really interesting court hearings gonna be happening in South Australia, which should be in the historical value almost, I'd say. So I'll be attending that in person, and hopefully it's gonna be all positive and helpful for further court hearings. All right, thank you for watching. If you got this far, leave a like and a comment, and thank you very much. All the best, guys.